Transfer of case comes supplementary item 2 the rupees 129 up to 123 along with item 3 to 5.
Just a minute. Baकी वो जो judgments का set था वो दीजिए. थोड़ा उनका सबमिशंस जो जजमेंट का था वो हम 2 लाइन लिखा ले रहे हैं, ठीक है. The learned counsel for the petitioner has relied upon judgment passed by this court in the case of Kamal Prasad and others versus State of Jharkhand, reported in 2011 SCC online JHAR 1050, para 21, 22, 25, 26, 27 to 31. ABC करके लिखिएगा, है ना. उसके बाद लिखिएगा judgment passed by Honorable Supreme Court in the case of State of Jharkhand versus Kamal Prasad and others, reported in bracket 2014 bracket close 7 SCC 223 para 33, 34, 36, 42 and 44. Judgment by Honorable Supreme Court reported in bracket 2018 bracket close 8 SCC 238 para 10, and while referring to the said paragraph, he has submitted that as per para 10, the case of regularization has to be considered under two distinct circumstances. A, if the candidate have completed 10 years of service on the date of promulgation of regularization rules. B, if they have completed 10 years of service, they should be regularized unless there is valid objection to their regularization. He submits that the second part of paragraph 10 is independent of the first part. This is what he has submitted. That is all. और तो कुछ नहीं. That's all. चलिए अपना बताइए.
Serial number 3 and 4 are together. The Bholanath's case, there is additional fact in that case. So
otherwise, whatever facts he has stated is correct.
Facts are correct. They were contractual employee. The extension of the contract was up to a particular date. That is also correct. Only the additional fact is in Bholanath case. So I may be permitted to place the Bholanath case because that is only one addition. That is not WPS number 2597 of 2023.
2597 of 2023.
Serial number 3.
Yes.
May I take to the page 31 of the writ petition or page 31. This is an Excel 3. This is the advertisement. Page 31.
Yes.
The advertisement itself, the tag copy has been given. भूमि संरक्षण निदेशालय झारखंड रांची के अधीन स्वीकृत कनीय अभियंता कृषि अभियंत्रण वेतनमान इतना के 22 स्थायी रिक्त पदों के विरुद्ध पूरे राज्य में संविदा पर सेवा प्राप्त करने हेतु संविदा मीन्स कॉन्ट्रैक्ट. इट वाज प्योरली अ कॉन्ट्रैक्चुअल. द एम्प्लॉयमेंट वाज प्योरली कॉन्ट्रैक्चुअल इन नेचर. द एडवर्टाइजमेंट
permanent vacant post but contractual.
But on contract. Then what are the terms and conditions of this advertisement? Next page.
It was on consolidated monthly payment.
It was, yes. Though the this grade pay and all has been given, the pay scale has been given, but it was on a monthly payment. Consolidated payment, that my lord was also fine. At page 33, the appointment letter.
So
Karyalaya.
we'll come to the you just come
Yes,
to
yes, the advertisement.
advertisement. Yes.
The terms and conditions, the relevant portion of the terms and conditions of the advertisement. Serial number 1, next page, type copy 31A. उक्त पदों पर नियोजन पूर्णतः अस्थायी एवं संविदा के आधार पर होगी एवं ऐसे व्यक्ति को नियमित रूप से नियुक्त करने समायोजित करने का विभाग सरकार का दायित्व नहीं होगा. He has accepted this and then applied. And the another one relevant person
Clearly mentioned that there would be no regularization or absorption.
Then serial number 4. संविदा के आधार पर इस नियोजन में वर्णित प्रावधान के अनुरूप नवीकरण नहीं होने पर ऐसे नियोजन स्वतः समाप्त माना जाए. So if the contract is not extended, then this appointment will be termed to be terminated. Pursuant to this, the petitioner applied, and the office order dated 27/12/2012 was issued. That is at page 33. One of the relevant portion of this annexure is page 35, wherein again the terms and conditions have been given.
Of 11 persons?
Of 11 persons. Including there are actually 21 persons, but out of this 11 persons were appointed. The terms and conditions are at page 35. Page 35, 3, subpara 3. अनुशंसित कर्मी को 500 रुपए के नॉन जुडिशियल स्टैंप पर निदेशक भूमि संरक्षण झारखंड के साथ एक इकरारनामा हस्ताक्षरित करना होगा जिसमें किसी भी प्रकार की संविदा विस्तार स्थायी नियमिती नियोजन का दावा नहीं करना सहित सभी बिंदुओं का उल्लेख किया जाएगा तथा इकरारनामा के हस्ताक्षरोपरांत निदेशालय में योगदान की तिथि से संविदा आधारित अवधि आरंभ मानी जाएगी एवं तत्पश्चात संबंधित कार्यालय में योगदान करने हेतु विरमित किया जाएगा. This categorically states that they will not claim for regularization and the appointment will be totally contractual in nature. Then serial number 5, Roman 5. किसी भी अभ्यर्थी की संविदा आधारित सेवा संतोषजनक नहीं होने पर या नियमित नियुक्ति होने की स्थिति में 1 माह की सूचना मानदेय देकर कभी भी सेवा समाप्त की जा सकती है एवं उनके द्वारा किसी भी प्रकार के संविदा विस्तार स्थायी नियमित नियुक्ति का दावा अनुमान्य नहीं होगा. इसके विपरीत कोई कर्मी नियोजन से स्वतः मुक्त होना चाहे तो नियंत्री पदाधिकारी के माध्यम से निदेशक भूमि संरक्षण झारखंड राज्य से अनुमोदन प्राप्त करना होगा.
Kindly come again to Roman 5.
मैम, यदि किसी अभ्यर्थी की संविदा आधारित सेवा संतोषजनक नहीं होने
ऐसा तो कोई केस
नहीं
आगे
या नियमित नियुक्ति होने की स्थिति ये है
रेगुलर एम्प्लॉयमेंट होगा.
हाँ, रेगुलर अपॉइंटमेंट का हम लोगों ने प्रोसेस इनिशिएट कर दिया. We have sent the requisition in terms of the rules. The rules have been also been framed that I will be placing. होने की स्थिति में 1 माह की सूचना मानदेय देकर कभी भी सेवा समाप्त की जा सकती है एवं उनके द्वारा किसी भी प्रकार की संविदा विस्तार स्थायी नियमित नियुक्ति का दावा अनुमान्य नहीं होगा. इसके विपरीत कोई कर्मी नियोजन से स्वतः मुक्त होना चाहेंगे तो नियंत्रित पदाधिकारी के माध्यम से निदेशक भूमि संरक्षण झारखंड रांची से अनुमोदन प्राप्त करना.
मिसकंडक्ट की स्थिति में हो सकता है डिसकंटिन्यू या फिर रेगुलर अपॉइंटमेंट की स्थिति में हो सकता है.
रेगुलर अपॉइंटमेंट. Now, Lord, after this,
no allegation of misconduct.
No. Lord, after
yes.
Lord, after this, the services of the petitioners, including the present petitioner, that was extended from time to time, and the last extension that my Lord may find at page 57. This is annexure 17, page 57. दिस इज विथ रिस्पेक्ट टू भोलानाथ. भूमि संरक्षण निदेशालय झारखंड रांची अंतर्गत संविदा के आधार पर कार्यरत कनीय अभियंता कृषि अभियंत्रण के अवधि विस्तार पर भूमि संरक्षण पदाधिकारी चतरा सहायक निदेशक सर्वे भूमि संरक्षण से प्राप्त अनुशंसा के क्रम में निदेशानुसार निम्नांकित विवरण के कॉलम 4 के अनुसार अंतिम रूप से अवधि विस्तारित किया जाता है. The fourth column, विस्तारित संविदा अवधि is there. This is 8/1/2021 to 17/1/2022 and the next is 18/1/2022 to 17/1/2023.
All post facto.
Almost. But and after this date 17th of January 2023, there is no relationship of employer and employee between the petitioner and the government as the contract has come to an end.
This is by way of last.
जी, ये अंतिम रूप से अवधि विस्तारित किया था by way of last.
फिर
Now, we have filed a counter affidavit wherein we have said that rules have been framed in the meantime when they were in service. The rules for filling up this post, that the post is junior engineer agriculture engineering services. The rules, my lord, may kindly find. This is counter affidavit on behalf of respondent number 3, 4 and 5, my lord.
2014 rules.
Yes, my lord. 2014 rules.
Yes, then what happened after?
Yes, my lord. I just wanted to place the relevant portion, my lord. The relevant part of this rule, we will have page 32, my lord.
Rules from 10th March 2014.
10 मार्च 2014. यह नियमावली झारखंड अधीनस्थ सेवा भर्ती एवं प्रोन्नति नियमावली 2013 कहलाई है.
क्या है इसमें?
This is Jharkhand agriculture.
No, there is no doubt on that.
Oh,
Rules have been framed.
My lord, rules have been framed, my lord, and the post of the petitioner, my lord, that my lord may find rule 4.3, page 32, my lord. Serial number 2, that there is a table given.
Serial number 3.
Serial number 2,
Serial
table,
number.
yes. कोटि 2 कृषि अभियंत्रण, एग्रीकल्चर इंजीनियरिंग कनीय अभियंता कृषि अभियंत्रण एवं समकक्ष. This is the post of the petitioner. And my lord, how this post would be filled up, that my lord may find at page 34. Page 34, my lord. अध्याय 2 भर्ती नियुक्ति 6 भर्ती का स्रोत. कृषि अधीनस्थ सेवा के पदों जो कि नियमित नियम 5 में उल्लिखित है कि 50% रिक्तियां झारखंड राज्य कर्मचारी चयन आयोग द्वारा आयोजित प्रतियोगिता परीक्षा के उपरांत की गई अनुशंसा के आधार पर भरी जाए. ऑन द बेसिस ऑफ द रिकमेंडेशन मेड बाय झारखंड स्टाफ सिलेक्शन कमीशन. और नेक्स्ट 50% के बारे में बोलते हैं. विभागीय प्रोन्नति समिति की अनुशंसा पर शेष 50% रिक्तियां कृषि अधीनस्थ सेवा की विभिन्न कोटियों के नियम 5 में वर्णित पदों के ठीक नीचे स्तर एवं समकक्ष पदों के अराजपत्रित कर्मचारी को द्वारा प्रोन्नति के द्वारा भरी जाएगी. प्रमोशन. In the light of this rules, the requisition has been sent by the concerned authority to the secretary of the personnel department. That my lord may find at page 42. Page 42.
11 post.
Yes, 42 42 कृषि अभियंत्रण कनीय अभियंता कृषि अभियंत्रण 11.
This is filled.
Much.
This has been filled.
No, but the process is still going.
Process is still going on.
Going, yes.
23. Okay. 23 में.
23. Maybe 9. Now, Lord, my next submission is, Lord, that if at all the claim of regularization of the petitioner is to be considered, or that has to be considered in the light of the rules, that has been framed in 2015. But the rules of 2015.
This is regularization rules.
Regularization rules. Lord,
Now
this
your simple case would be that as per the fresh rules, 50% by promotion and 50% by direct recruit. And so far as direct recruit is concerned, there is only 11 persons.
11%.
Right? Promotion post cannot be filled up by them because they are not entitled for promotion. It is only the direct recruit. You have initiated the process for direct recruit.
Yes.
In which persons must be participating. We do not know what is the status, but process has been initiated.
It has been initiated.
But as per your appointment letter, you have to continue them till it is filled up by regular recruits. So you continue them. But so far as regularization is concerned, it is difficult to grant them the relief. That I must make my mind. Apparently, it appears to be so, subject to what.
Because now they have to fulfill the criteria which has been laid down in the rules. Up to the cut-off date, earlier the cut-off date was 10th of April 2006. It was extended up to 2019, Milord. So their appointment is in 2012. Till 2019, they do not complete 10 years of.
They have not yet come up with any plea that they want any relaxation.
No,
nothing.
No.
There is no such plea.
No such.
This has been advertised so far. No.
Advertisement is not there, Milord. Only requisition have been sent. The process has been initiated. Milord, this rule of 2015, it was formulated.
You don't want to use their expertise. They have been working for so many years. Do you want them to participate in your recruitment process by giving them some age relaxation?
No, with respect to that,
there is no instructions. But as of now, there is no such proposal. As of now, there is no such demand also from them.
They don't say that I may be permitted to
participate in the selection process.
They do not say that you regularize me on the basis of the 2015.
So if they are regularized, this recruitment process will be frustrated completely. Because there are 11 in numbers and only 11 posts for direct recruitments. Then this particular rule will be of no use.
Certainly.
Till they attain the age of retirement.
Because if at all they have to be considered for regulation, it has to be under this rule.
Under this rule.
Under this rule.
No, if they have to be considered for regularization, then the vacant post will be only 11.
Then
and no more.
No more. After this one, there will be no post.
No post for regular recruitment.
No
till they attain the age of superannuation. Got it.
Well, this rule was framed in the light of the judgment passed by the Honorable Supreme Court in case of Uma Devi and ML Kesri. I will just read the preamble. Preamble.
There is no doubt, we have read it so many times. Anything in particular you want to say?
And Malad, just wanted to place few judgments.
What was the cut-off date?
Yes, cut-off date. Yes, earlier, Milord, the cut-off date was clause 3.
10th April 26.
It was. Sorry.
10th April 26.
10 अप्रैल 2006.
उसका नया cut-off date क्या है?
That was extended. Last page में kindly. I flagged it.
Yes.
3 का two columns are there. First one, पूर्व में अंकित प्रावधान, the earlier provision and the संशोधित प्रावधान. संशोधित प्रावधान नरेंद्र कुमार तिवारी एवं अन्य बनाम राज्य झारखंड अन्य में दिनांक 1/8/2018 को पारित न्याय निर्णय के आलोक में प्रस्तुत संबोधन संबंधी अधिसूचना के निर्गत होने की तिथि को आधार तिथि मानते हैं. So the date would now be shifting to 20th of June 2019. प्रस्तुत संशोधन संबंधी अधिसूचना के निर्गत होने की तिथि.
So 10 years should be completed on 20th of June 2019.
Because their appointment
is 2012.
2012. 27/12/2012.
I think that should be sufficient. और कुछ बहस करना?
नहीं, एक और चीज बस खाली जजमेंट है. Lord, this is ML Kesri has been praised by my learned friend, Lord. And the another one is Narendra Kumar Tiwari, on the basis of which the 2019 rules have come.
एमएल केसरी का आप कौन सा पैराग्राफ?
Yes, madam. Paragraph 8 to 11. Yes.
अभी जो बैठे थे आप ही थे? सॉरी, कोई और?
And the Narendra Tiwari's case number 5, 6 and 8. Para 5, 6 and 8.
नरेंद्र तिवारी पारा 5, 6 and 8.
But I pointed out.
5, 6 and 8. This is 8. That's all.
Those are times. Man.
The learned counsel appearing on behalf of the respondents has.
With respect to contempt, madam.
Yes, complete that also.
Already, so far as this contempt law, contempt civil number 785 of 2023 is concerned. The order was passed by the Honorable Court on 17th of July 2023, page 41 to the content application.
Page number?
Page number 41, Lord. This is order dated 17th of July 2023.
Yes.
Wherein the Honorable Court, Lord, it is made clear that if petitioner is working, he will not be removed without the prior approval of this court. Mother. We have filed a so cause that after this order, the petitioner himself filed an application that is on 23rd of August 2023. That is annexure 13 at page 47.
Of the main petition?
Yes, ma'am. Main content.
Page 47.
Page number is 47. Annexure 13.
Yes.
The order passed by this Honorable Court is 41, Lord. This is dated 17th of July 2023, and after that, on 23rd of August 2023, the petitioner filed an application. The
Can you read this?
yes, ma'am. Subject: for compliance of interim order dated 17/7/2003, passed in WPS number 2597/2023, reference my reinstatement in service of junior engineer in the office of Soil Conservation Officer Chatra. Respected sir, kindly find enclosed herewith the interim order dated 17th of July 2023, passed in WPS 2597/2023 for compliance as admittedly on date the same was passed. I was working, which can be well verified from my attendance and work done from the office. It is also a matter of record that I was never removed nor any order of removal has been served upon me. Further, in similar situation, other 10 persons have also been working without any break and has obtained similar order. Hence, I may also be allowed to work till disposal of my pending writ petition. After this, Lord, we have called for an report that my Lord may find in our so cause, that is so cause on behalf of OC number 2 and 3. Annexure B at page 12. A report was called for. Page.
That's right.
Yes, ma'am. This is pressure. It has been written by Nideshak, Bhumi Sanrachan, the Director Soil Conservation, to the Soil Conservation Officer Chatra. उपयुक्त प्रासंगिक के विषय के संबंध में कहना है कि श्री भोलानाथ पूर्व कनीय अभियंता चतरा के पत्रांक 0 दिनांक 23/8/2023 द्वारा यह सूचित कराया गया है कि उनके द्वारा दिनांक 17/7/23 तक कार्य किया गया है, जबकि आपके द्वारा पूर्व में निदेशालय को यह अवगत कराया गया कि भोलानाथ द्वारा अपने कार्य का निष्पादन 15/6/23 तक किया गया है। चूंकि ये न्यायिक मामला है, अतः निर्देश दिया जाता है कि तथ्यों की जांच करते हुए इस संबंध में अपना स्पष्टीकरण 2 दिन के अंदर निदेशालय को प्रस्तुत करें। But prior to this also a report had come, that is annexure A at page 11, the earlier page. This is 25th of August 2023, and prior to that on 8th of August 2023 a report was given. इट सेज उपयुक्त विषय के पेज 11 में उपयुक्त विषय के आलोक में सादर सूचित करना है कि संविदा आधारित कनीय अभियंता भोलेनाथ द्वारा अपने कार्य का निष्पादन दिनांक 15/6/23 तक किया गया है। इस अवधि के बाद इनसे कार्य नहीं लिया एंड pursuant to letter dated 25th of August 2023 another report has come that is at page 14 and it is C मैं प्लीज उपयुक्त विषय एवं प्रासंगिक पत्र के आलोक में सादर सूचित करना है कि संविदा आधारित कनीय अभियंता श्री भोलानाथ के द्वारा अपने कार्य का निष्पादन दिनांक 15/6/23 तक ही किया गया है। इस अवधि के बाद इनसे किसी भी तरह का कोई कार्य नहीं लिया। Since he was found not working, Lord, therefore his contract was not extended further. And alright, a distinction has also been made with respect to other persons. Note para 6 in the so-called we have said para 6 that is most humbly stated and submitted that the extension of all above stated petitioner was done by the answering opposite party in compliance of the direction of the Honorable Court by order dated 14th of February 2023 passed by this Honorable Court in WPS number 159/23 because at that time of passing of the order by this Honorable Court the state petitioners were working. The operative part of the state order is here under it has been quoted and then para 7 it is respectfully stated and submitted so far as the present petitioner is concerned his contract was valid up to 17/1/2023 and thereafter his contract has neither been renewed nor extended by the department. That while letter number so and so the soil conservation officer etc. informed that petitioner has worked till 15th June and thereafter no work has been done.
That's right. The learned counsel appearing on behalf of the respondents while opposing the prayer has submitted that has advanced his argument from the records of WPS number 2597 of 2023 and Contempt Civil 785 of 2023 in which the petitioner is one and the same person. The learned counsel has also submitted that so far as facts narrated by the petitioner during the course of arguments with regard to other petitioners are concerned, there is no dispute. The learned counsel submits that the advertisement has been placed on record at page number 31 of the writ petition, and as per clause 1, as per the advertisement, though the posts were permanent, but recruitment was only for on contractual basis for a period of 1 year subject to renewal. As per clause 1, the employment was temporary and contractual, and the incumbent could not claim any regularization or absorption. He has also the learned counsel has also referred to clause 4 thereof to submit that in absence of non-renewal, the contract will stand discontinued. The learned counsel thereafter referred to Annexure 5, which is Office Order dated 27/12/2012, to submit that as per the office order also, similar clauses are there, and it has been specifically mentioned in clause 3 within bracket Roman 3 thereof that an agreement is required to be executed for the purposes of joining, and as per the agreement, no claim for extension / absorption or regularization will be entertained. And he has also referred to clause 3 within bracket Roman 5 of the said office order and has submitted that the incumbent could be removed on account of misconduct or upon regular employment. The Learned Counsel has submitted that for the purposes of regular employment, rules have been framed by notification dated 10th of March 2014. He has referred to clause 4.3 of 4.3 within bracket 2 of the rules and has further referred to clause 6 within bracket 6.1 and 6.2 to submit that 50% posts are to be filled up by direct recruitment and 50% through promotion, and total sanctioned posts being 22. 11 posts were to be filled up by direct recruitment and 11 by promotion. He submits that steps were taken by issuance of letter dated 2/5/2023 to JPSC for filling up the 11 posts.
This requisition has been sent to by the Agriculture Department to the Personnel Department.
Okay, the requisition has been sent by the Agriculture Department to the Personnel Department of the state of Jharkhand for filling up the post of 11 direct recruits, and the Learned Counsel has submitted that the total persons involved in the present case are 11 in number, and if they are to be absorbed or regularized, they will occupy the 11 posts for direct recruits, and the rules which have been framed by notification dated 10th of March 2014 will become meaningless. Right? By any means they cannot be adjusted against promotee post. He submits that this is without prejudice to his argument that the petitioners are not entitled for regularization in view of the terms and conditions of the advertisement and their appointment. The Learned Counsel has further submitted that so far as the contempt is concerned, the petitioner Bholanath had his extension only till 17/1/2023, and the interim order was passed
Page 41, 17/7.
on 17/7/2023. The Learned Counsel has referred to the representation of the petitioner Bholanath dated 23/8/2023 annexed as Annex 13 to submit that he claimed that he made a prayer for, he filed a representation for his reinstatement in service of junior engineer and had stated that on the day the interim order was passed, he was working in the office. The Learned Counsel submits that pursuant thereto, an inquiry was conducted and a communication was received mentioning that the petitioner Bholanath had worked only till 15/6/2023, and on the date of passing of the interim order, no work was being performed by Bholanath, and therefore the respondents have not committed any error or any violation of the orders passed by this court for not extending the benefit of order dated 17/7/2023 to Bolana. Right? That's all. Second, the Learned Counsel has relied upon the judgments passed by the Honorable Supreme Court reported in bracket 2010 bracket close 9 SCC 247 State of Karnataka versus ML Kesri and others, paragraph 8 to 11, and also the judgment passed in case of Naren Kumar Tiwari versus State of Jharkhand reported in bracket 2018 bracket close 8 SCC 238 paragraph 5, 6 and 8. And as the Learned Counsel has further relied upon the notification regarding regularization which has been issued by the state by as a sequel to the judgment passed by the Honorable Supreme Court in the case of Uma Devi and ML Keshri, which is dated 13th of February 2015, and has submitted that initially the cutoff date was taken as the judgment passed in the case of Uma Devi as 10th April 2006 for completion of 10 years of service, and subsequently by virtue of the order passed in the case of Naren Nath Tiwari, the cutoff date for completion of 20 years was taken as 26/2019. He submits that on 26/2019, the petitioner did not complete 10 years of service, and accordingly, the petitioners are not entitled for regularization as per the scheme framed by the state of Jharkhand. That's it.
My lord, two judgments we have given the list of those, though we can't produce the copy. May I please refer to, or I'll give the copy.
What judgment?
My lord, two judgments, my lord, that was having accepted the purely temporary post, my lord. Now they cannot contend claiming
Which
of
is
the benefit.
that judgment?
Yes, no, this is my lord, 2018 volume 9 SCC 293
293 para.
para 14.
The Learned Counsel has relied upon the judgment passed by Honorable Supreme Court reported in bracket 2018 bracket close 9 SCC 293 para number 14 to submit that the petitioners having accepted the terms and conditions of advertisement and the appointment, they are not entitled for any relief by way of regularization of their services. That's all.
And absorption in service is not a right. Regularization is also not a statutory or legal right.
The Learned Counsel has also submitted that the regularization or absorption in service is not a right of the petitioner. The same has to be done as per the policy and the scheme framed by the respondents.
This is 2012 volume 6.
2012
volume 6 SCC
12 volume 6 SCC
502
502
para 172.
172 Done?
My
आपको क्या बोलना है response?
minutes.
Please don't repeat your argument
No,
in
I'm
response.
not
what
repeating,
you
I
say.
will not repeat anything.
Yes.
Lords, one thing that my learned friend had missed, and which has been taken care in the Milos Honorable Supreme Court judgment in Kamal Prasad, that it is a case of regularization, not appointment. Kindly appreciate, my lords. And by virtue of the judicial pronouncement, the Lordship has considered paragraph, kindly see the Kamal Prasad judgment, my lords, that compilation that I have given, in which paragraph 34. The Lordship has said this argument was made that since the post of assistant engineer and junior engineer is a post to be advertised and appointment to be made by the commission, therefore they are not entitled
You
for
have
regularization.
placed that paragraph. We
Paragraph
have read
34.
it. We
Paragraph
have read
34.
it. आप पढ़े पूरा text.
34 नहीं, कमल प्रसाद नहीं पढ़े थे हुजूर।
कमल
वो तो-
प्रसाद
कमल प्रसाद का
में-
डिवीजन बेंच पढ़े थे हाई कोर्ट का, सुप्रीम कोर्ट का नहीं पढ़े
एक
थे।
ही बात है ना, कोई नया
हुजूर
बात
हमको बहुत कुछ बोल गए हुजूर, हमको तो जवाब तो हुजूर देना दिया जाएगा ना।
रिपीट मत करिए, हम
एक
देख
लाइन
लिए
रिपीट नहीं करेंगे हुजूर, कमल प्रसाद तो छुए नहीं अभी तक हम, खाली उसको देख लिया जाए, हम
Please
पढ़ देते
hold
हैं।
on.
जी
ये जो पब्लिक सर्विस कमीशन के थ्रू अपॉइंटमेंट की बात थी, यू हैव प्लेस्ड द डिवीजन बेंच दैट प्ली वाज रिजेक्टेड.
plea was rejected and how it has been meted out in the Supreme Court, but the Supreme Court said, kindly see this paragraph 34. Their Lordship has clearly distinguished that they are making a requisition at this stage. Why? When our right has precipitated for regularization under the mandate of law, they could not have done this. Therefore, we have come here. And therefore, there is a distinction between regularization and appointment. All that they are arguing that we have framed a rule, appointment process is different. All those things will come when I will coming against the laws for the appointment. I am not coming for the appointment. I am coming for the regularization, which is flowing the right under the mandate of the laws, the Supreme Court, exceptional direction, Rule 53, paragraph of the Uma Devi, and thereafter laws culminated in Emal Kesari, and this was Kamal Prasad. And paragraph 34 kindly simulates this judgment. And why all these exceptions? Article 21 will prevail over everything. This is the ultimate Mullah's. So it is an exceptional exercise to that of Article 14 and 16, and Mullah's this rule, regulation, etc. will not override. And who is responsible for all these things, Mullah's? They are responsible. Can you see paragraph? Further, the senior council, paragraph 34, and what I am reading, Mullah's. Council that urge that principle which flow from the mandate of Article 14 and 21 of the Constitution of India is separated at paragraph 53 of the Uma Devi case. It is further contended that it is not a case of appointment as mentioned hereinfore, but it is a case of regularization. The only qualification for latter is continuous service of employees without intervention of the court order for a period of 10 years. Once this takes place, the citizen's right to livelihood is guaranteed under Article 21 as also in his right to fair treatment, and against arbitrary action of the appellant is protected by Article 14 of the Constitution of India. That is the ratio of the impugned judgment of the division bench of the High Court. The conclusion that finding and reasons recorded by the division bench of the High Court on this aspect of the matter in this impugned judgment is squarely covered by the constitution-based decision of this court in Olga Teli versus Bombay Swenso. The relevant para of the same will be extracted in the reasoning portion of the judgment. Therefore, the London Senior Council has prayed for dismissal of the appeals. All the other London Council appearing so-and-so. Now, let's paragraph 36, the question framed by the Supreme Court, and exactly same question which covers my case. With reference to the above rival contention urged on the behalf of the parties, the following points would arise for consideration in the civil appeals. Whether the impugned judgment, paragraph 36, the question was framed by the Supreme Court. Whether the impugned judgment is correct in holding that the respondent employees are entitled for benefit of Uma Devi case as they rendered more than 10 years of the service in the state government of Jharkhand.
First, let us be very clear that para 34 is the submission.
Submission, an answered letter. Why must I have read this? This is the proposition that I am adopting that argument.
Okay.
I am adopting that argument, my
That's
lords.
fine.
That
That's fine. This is not
rule
a
of
finding.
regularization, my lords. Rule of regularization is
We'll
an
come
exception
that,
to Article
but
14.
That is not a finding of the Honorable Supreme Court. Para
that has been
34, maybe that submission has been accepted later.
Therefore,
but that is not the finding as such.
Therefore, this letter I am reading. I am reading letter. I'll see how it has been accepted by the Supreme Court and endorsed. With reference to above said rival contention urged on behalf of the parties, the following points would arise for consideration in civil appeals. Whether the impugned judgment is correct in holding the respondent employer entitled for the benefit of Uma Devi case as they rendered more than 10 years of the service in the state government of Jharkhand without intervention of the court. So this is the crux of the question, my lords. Whether the impugned judgment passed by the division bench of the High Court is vitiated on account of erroneous finding or suffers from error of law. Whether the impugned judgment warrants interference by this court in exercise of the power under Article 136. Plus, the argument that I have made has not been even rebutted by the opposite side. They are not touching this portion. They are singing the lost the argument.
If they are not touching your point, you should be happy about it.
Therefore, I am happy, Milos. Therefore, I am emphasizing that stands was accepted in the Milos law of non-traverse. And our cases of regularization, not appointment. And you ate the appointment. And what they say, two conditions for termination: appointment regular made or misconduct. Neither is there a terminated. How? This is what I am saying, that this is grossly arbitrary. So, when our right for regularization precipitated under the law of the land, they immediately awoken how to circumvent and defeat that right. And therefore, this requisition. If 2014 rule is there, my lords, lordship will appreciate what prevented them from making this requisition in 2014, 15, 16, 17, 19, 19, 20, 23. So, lordship will kindly have a pleasure of appreciation, the relative assessment that why they are swinging in action at this belated stage. When they get awakened, when they started demanding our right, which has been precipitated under Article 21 by virtue of this dictum of the Supreme Court, they were lost in order to defeat that mandate to the law and my right under Article 21. They made this requisition, which is 8 minutes in the hibernation, till that no result thereof. Therefore, Mulas, I am saying that conduct and the argument will not throw away my right of regularization, which is precipitated under this law of the land. And that is a colorable argument and colorable device that they have adopted in 2024. They could have done it in 2014-15 Mulas. Therefore, the Supreme Court says that once this right has precipitated, it will be dealt under the realm of regularization, not in appointment. So, therefore, Mulas, after these three questions framed, 1 and 2 Mulas, the points are answered together as they are interrelated with each other. The senior counsel appearing on behalf of the appellant argued there have been a repeated finding of the High Court that the respondent have been continuing in service voluntarily employed for more than 10 years. Correction of the same is disputed by the senior counsel for the appellant. Appellant's reliance upon so and so. After, I will not read the formulas. Paragraph 39 is the quotation. Paragraph 53 of the Umadevi is quoted. Herein, Mulas, the word used is Mulas all temporary or daily wage employees. And then, Mulas, after dealing with all this, the Lordship has, Mulas, ultimately paragraph 42, kindly have a pleasure, Mulas, straight away. This quotes the, Mulas, the Olga Teli case, wherein the right of life, Article 21, has been, Mulas, has been quoted and taken care of the Supreme Court in a very, Mulas, very exceptional style. And what has been held, Mulas, if Lordship may permit, I may read it or I may escape it, Lordship may consider it, Mulas. Then ultimately, Mulas, after taking into consideration Article 21 as a paramount right, which will override everything, the Lordship ultimately, paragraph 43 and 44, in view of the foregoing reasons, which we have assigned in this judgment and upholding the finding and reasons recorded by the division bench of the High Court in impugned judgment, it cannot be said that the finding of reason recorded by the High Court in arriving at the conclusion on contention issued arose for its consideration can be termed as erroneous in law. In view of the foregoing reasons, we are inclined to conclude that the High Court was legally correct in extending the benefit of Umadevi case to the respondent employee. Therefore, we answer the point 1 and 2 in favor of the respondent employee. So these two questions have been answered in favor in an exceptional situation of Article 21 vis-a-vis the exceptional direction under paragraph 50 Umadevi, which by itself is the exceptional. Therefore, all these arguments, therefore in my rejoinder, which I have filed in Mulas, kindly see this rejoinder in case number Mulas 129, and have a pleasure of this Mulas. And not there are the contract. They say that one have to enter the contract. They have enclosed the contract. They are not reading the contract. What they say in contract? Kindly see this. They have gone to the extent. Kindly see Mulas, this counter affidavit they have filed, and the contract they have enclosed. In contract, they say,
if we have to interpret the contract, we will not enter.
No, I am not saying so.
So then
they have gone up to the extent of saying that you have no right to file a writ petition in the High Court. Is it a binding contract, Mulas?
Have we dismissed it on this ground?
No, all that I am conveying, Mulas.
It's a sham. It should be thrown into dustbin.
No, all that I am trying to argue, Mulas. In a rejoinder, I have taken a point.
No, you need not. You see, we have heard you fully. You now. On the point of law you are responding, you cannot start your argument again. Because you never,
rejoinder I am reading.
Rejoinder, you never refer to the contract at the time of argument.
Well, contract is there. They have I have not. I have already sought a leave to my lords that something is left out to me.
No,
Lordship, give me the latitude.
You see, it can't be like this, Mr.
I am for the pleadings, Lords, not out of the pleadings.
You forget the contract. You forget the contract.
I am forgetting the contract.
Yes, you forget the contract.
I am forgetting the contract. In the contract, they say that you will not be even approach the High Court. You are injuncted from approaching the High Court.
But you have still approached.
Approached?
Have
why?
we dismissed you on that
Why?
ground?
Because that is the right under Article 226. They cannot enter into contract.
We are not in a lecture session, Mr. Please appreciate. You see, irrespective of...
Lords, if something wrong is going on my part, but I am trying to defend
nothing
my
wrong.
rights.
I am hearing you for 2-3 hours now. You say something wrong is going on.
Therefore, I am saying the magnum of the case.
We have not thrown out your case on the basis that it is a contract. You argue in most of the case. I'm not going to enter into the contractual
clauses. The documents which they have brought on record, the respondents.
We have
what they are saying, Milos, now they are taking resort of this rule, regulation, contract. All will not override the Article 21 and the paragraph 53 of the Umadevi. That is all I am saying, Milos.
Do you want to say that I have to be taught that Article 21 will be above all this?
I am arguing, Milos, for
so
Lordship consideration.
We are aware of this.
Very well, I am obliged to Lordship. Lordship has already taken that care of the argument, Milos.
Article 21 will be above all the
so, Milos,
naturally.
Therefore, Milos, only two things more, Milos. In my rejoinder, I have Milos said that the judgment that my lord is, my friend is relying upon, that after once you have accepted the contract, etc., it will not be revert back. All those judgments are of the scheme workers. There is Mohan Lal, plus etc. All are of the scheme workers, where the scheme is coterminous. And a scheme, we are not a scheme worker.
They have not relied upon any judgments excepting two which you have also relied upon.
No, just now he has given one judgment, which
We'll
is a
see
scheme
that.
worker.
We'll see that.
My submission below for lordship and consideration. And another judgment argument is below that this contractual terms etc. are in the teeth of section 23 of the Contract Act.
फिर आप section 23, आप 21 पर argue कर रहे हैं, 23 Contract Act
उसको बंद कर दिए, हुजूर का आदेश हो गया, बंद कर दिए उसको. So in rejoinder I have said all that. And one thing more. All aspect will be covered by the letter of the director himself, which is made for recommendation for regularization. So that is the trump card, and that is the actual intention and state of affair.
That's right.
So these conditions etc. will not override the mandate and the recommendation. And क्या क्या और बहस की है कमल प्रसाद. हाँ, एक चीज पूछे थे सुबह हुजूर की 1981 से कब कैसे उसका रिकॉग्नाइज कर दिया.
हमने कुछ पूछे थे.
कमल प्रसाद
कोई जरूरत नहीं है उसको पूछने
वो
का.
जजमेंट हुजूर उसमें हुजूर के बेंच में है, पैराग्राफ 15-16 है वो जजमेंट 15 का 8 है सीसी 163. उसी में हुजूर क्लैरिफाई हुआ सुप्रीम कोर्ट से.
आपको लगता है हम फुल टेक्स्ट जजमेंट पढ़ते हैं, आप लोग नहीं भी पढ़ते.
हुजूर के कंपाइल में है मेरे
हम पढ़.
तो पारा 15-16 है, खाली 15 नंबर पारा नंबर लिख लेना मेरे उसका. कुछ सवाल हुजूर पूछे थे तो हुजूर हम वो पढ़ के आए थे कि वो कहां पर है, तो वो 15-16 में है. ये हुजूर गौरी शंकर राय वर्सेस सजल चक्रवर्ती. This is the judgment follows in contempt of this Kamal Prasad. Okay. It has to be read together with this.
अब बैठ जाइए प्लीज. अब बैठ जाइए.
ठीक है तो अब कुछ छूटा नहीं, जो वही देख रहे थे कि क्या क्या ही बोले हैं, बहुत कुछ
लिखिए. The learned counsel for the petitioner in response has referred to paragraph number 34 of the judgment passed by the Honorable Supreme Court in the case of State of Jharkhand versus Kanda Prasad, Supra, which is the submissions made by the learned counsel appearing on behalf of the employees. He submits that ultimately the issues were framed in paragraph number 36 of the judgment, and out of the three issues he is concerned with, issue number 36.1 Roman 1 and 36.2 Roman 2. The learned counsel has submitted that the Honorable Supreme Court has taken care of paragraph 53 of the Uma Devi's judgment, as well as the judgment passed in the case of Olga Telis, reported in bracket 1985 bracket close 3 SCC 545, to submit that right to life under Article 21 cannot be defeated by the device of the respondents. The learned counsel has referred to paragraph findings in paragraph number 43 and 44 of the judgment, and has submitted that the present case is not a case of appointment, but it is a case of regularization. Once the condition precedent, that is the period of 10 years, is completed, the petitioner is entitled for regularization. Such claim cannot be denied by the respondents. That's all.
Response may I make one line?
One line. एक सेकंड जरा सा
दूसरा कोर्ट में भी ऐसा करते हैं क्या?
होता है.
2 नंबर कोर्ट में तो कभी नहीं किया आप लोग.
2 में तो कुछ बोलना नहीं होगा, वहाँ बहुत खतरा है.
नहीं, ऐसा नहीं बोल सकते हैं. नहीं, आप ऐसे ही करते हैं, एकदम मछली बाजार बना देते हैं दूसरा कोर्ट में.
दूसरी जगह नहीं, मछली बाजार नहीं हुजूर.
मछली बाजार
सवाल है लोगों का.
मछली बाजार बनाना.
हुजूर एक जजमेंट और दिए थे, जो नया जजमेंट जो रिसेंटली जो झारखंड हाई कोर्ट से आया है, NN तिवारी वाला. NN तिवारी के 2 जजमेंट आ गया. एक NN तिवारी का जजमेंट आया.
हम सब सुन लिए हैं.
हाँ, जो NN तिवारी में क्या हुआ कि ये जो 15 और 19 का
15
और 19 का रूल कंसीडर हुआ और उसको रिजेक्ट कर दिया गया.
There is no end to your
नहीं, हम ये कह रहे हैं कि 19 में जो अमेंडेड रूल बनाए थे, दैट्स बीन रिजेक्टेड by this high court by saying that these rules are not in conformity with the Supreme Court judgment.
So set aside हो गया rules.
It has been read down. Set aside is not necessary. Kindly see this paragraph of this NN Tiwari judgment 2023 1 JBCJ page 500. The lordship held that all the rules are not in consonance with the Supreme Court mandate. Therefore, it has to be read down. Kindly see this.
The Learned Counsel has also relied upon the judgment passed
In
by
2023, 1 JBCJ
this
500.
court by a coordinate bench reported in 2023 within bracket 1 JBCJ 500 and 500 पैरा नंबर बताइए.
पैरा प्लस पैरा जो इसमें तो है 24, 30, 36, 37, 41 से 44 और 45. जो हुजूर
पूरा अंग्रेजी में बोलेंगे.
सॉरी 24,
24,
30,
24, 30,
36,
36,
37,
37,
41 to 44,
41 to 44,
41 to 45 plus.
41 to 45.
Lordship.
To submit that, this court has held that the rules of regularization of the year 2019 has not been framed in terms of the judgment passed by the Honorable Supreme Court
Grateful.
in the case of Uma Devi.
Uma Devi read with was this
Read with ML
Read with-
Kesri and read with
Narendra Kumar Tiwari,
Naren Kumar.
Mr. Jharkhand 2018 8 SCC 238. So ultimately I am only
अब बस-
I am concluding.
नहीं,
अच्छा ठीक है.
you have already concluded.
They need more sympathy with their.
मेरे patience का test मत लीजिए.
ठीक है ठीक है.
Please don't.
बंद करो.
आप लोग के साथ साथ इसलिए लिखाते हैं कोई बात आपका छूटना नहीं चाहिए. कल को ये मत बोलिएगा कि ये भी बहस किए थे और कोर्ट ने ध्यान नहीं दिया. This is the worst allegation on a judge.
नहीं ये तो हुजूर के यहाँ सवाल ही नहीं उठता
नहीं,
है.
I do not know.
क्योंकि कभी भी ये नहीं
This
हुआ.
is the worst allegation which can come for a judge that a point was argued was not taken care
नहीं
of.
हुजूर के कोर्ट में कभी नहीं हुआ है. और हम लोग देखे हैं कि एक चीज हुजूर एग्जॉस्टिव लिखा रहता है उसमें.
Judgment को detail कीजिए.
मेरा एक लाइन सबमिशन था. ये जो 2014 का जो जजमेंट प्लेस कर रहे हैं ना, स्टेट ऑफ झारखंड वर्सेस कमल प्रसाद, बट दिस वाज डिसाइडेड ऑन 23rd of April 2014. On that day, the regularization rules was not. Therefore, he says that his right has precedence.
Milords, rules will not come in my way.
हम समझ गए आपका बहस.
Grateful Milords.
आप ऐसा क्यों सोचे कि आपका बहस हम नहीं समझे.
Rules is executive exercise. It cannot.
अब वो अलग बात है कि
अब जो 2023 में रिक्वेजिशन क्यों भेज रहे हैं, वही तो कारण है कि इसको डिफीट
उस
करना है.
रिक्वेजिशन का चैलेंज नहीं किए.
जरूरत नहीं है हुजूर के हम पहले आ गए. हम मेरा राइट हुजूर के यहाँ से हो जाएगा. That will be done away. Therefore, I have no urgency of this case.
For judgment on 14th May.
14
एक और गया है.
आज
ठीक है 14th में दोनों करते हैं.
14th May. No, still then, Bholanath should be allowed to work. Because Lordship has at least appreciated that.
इतना दिन आप लोग पेशेंट रखें, थोड़ा और पेशेंस रखें.
छोटे
इस तरह से ऑर्डर रिजर्व करते समय हम कोई इंटरिम ऑर्डर नहीं पास कर सकते.
एक तो बचा हुआ हुजूर जो बेचारा बाहर है. All are getting the salary and
Mr. Counsel, one thing, you have taken a decision as per your contract also that they would continue till regular employees are appointed, right?
That is there.
That is there.
तो फिर तो कम से तब तो हुजूर कम से कम उसको भोलानाथ को काम करने दे हुजूर. उतना कर लीजिए.
आपको क्या लग रहा है हम जजमेंट प्रोनाउंस किए हैं?
हुजूर के जो पूछे
हम उनसे इसलिए पूछे क्योंकि ये चीज मेरे दिमाग में है तो पूछ लिए. If he has to say anything, he would have said.
He is the officer of the court, Milords. He
Right.
can also help us in imparting the justice.
Pastor case item 6 Kalupius 900 out of 123.
वो तो वो चीज पॉइंट आउट किए जो आप पॉइंट आउट कर ही नहीं पाए.
हम तो उसके लिए आए नहीं हुजूर. हम तो आए रेगुलेशन के लिए. वो तो हुजूर हम जानते हैं कि हुजूर उसको बेसिक लॉ से हुजूर उसको डील कर लेंगे. Grateful obliged for Milords present.
Yes, what is it?
Yeah, please, Ladyship. Petitioners have moved for quashing of Annexure 7 series, which are orders dated 1/10/2022, 31/12/2021, 19/11/22, and 5/10/21. Now, before I take your leadership with the relevant reviewed order, may I be please permitted to place the case, the factual case at hand, Your Ladyship. These were para teachers working, and they applied for appointment as assistant teacher when the advertisement was floated.
Which category?
Para category. All of the teachers, all of the petitioners applied for para category. Now, Ladyship, this is the third round of litigation. Now, I may be permitted to place only 2 orders that were passed by
What was the first round?
Yes, Your Ladyship.
Where is that order?
Yes, Your Ladyship. That order is at Annexure 3, page 51. All the petitioners were there in the first round of
Page 51.
Your Ladyship, maybe I am permitted to read this order because there is an issue that was raised by the state that it is not incumbent upon the state government to fill all the vacant posts. So that
No, those stories are all
Yes,
over.
yes,
Now
yes.
now I think the fresh
Yes.
advertisement has been made.
Yes, Your Ladyship. Now
So those stories are already
yes,
over.
but what has
It does not survive
happened and what has happened, Your Lordship, that this order as well as the second order that was passed in respect to these petitioners, in what manner have they been flouted? I am only going to indicate.
It doesn't make any, it doesn't cut any ice because those stories are already over. You were para teachers working, you applied under para teacher.
There was specific direction of these of the Honorable Court to fill up all the vacant posts, Your Ladyship. Here, pursuant to this
You see,
order,
you are aware.
yes, pursuant
Since those vacancies were not filled up, there is a further direction for counselling.
I was there, I appeared in that counselling. My name was there, and in spite of the said fact,
You appeared in the counselling pursuant to the order passed by the
pursuant to the order passed by the High Court. Now, Your Ladyship, once I appeared in the counselling and I was not selected, I again preferred a writ petition. That order is very important. What was the second order that was passed in respect to these petitioners, which is at page number annexure, page 86. And in this, the state conceded that I have a right and I would be considered. Yes, Your Ladyship. At paragraph 9, they conceded. And in spite of that,
What is the marks of the last selected candidate?
the last selected
Have you scored more marks than
No, I haven't scored more marks than that.
They
But-
have refused your candidature on the ground that they could not call the other persons because you had a specific order in your favor,
Yes, Your
and 103 persons were there above you and they were not called.
But that is the case in other cases. May I be only allowed to place the case of Vinay Kumar Saab, in which it's not the case that 103 petitions are above me. 103 persons are above me. In this case, they considered that 8 seats are vacant. I have the right because 7 are left out in my category and I have a right to be appointed. It's their case.
Now you see, if you have a right under the orders, we are not going to pass any different order, whatever has been passed by the Honorable Division Bench. We can dispose of this case in terms of the order of the Division Bench. Nothing more. The moment we start adding any further clause, any further ground, this will frustrate the new process which has been initiated. We are not going to do that. In terms of the judgment passed by the Honorable Division Bench, if you are entitled, you will get it. If you are not entitled, you will not get it.
I bow down. Your
Simple.
I bow down. 89.
If it is for you to consider they are entitled, not entitled. In terms of the latest judgment of the Honorable Supreme Court, if they fall, you consider. If they do not fall, you do not consider. We do not want to add a word to that judgment.
Because only if I may be permitted, Your Worship, they have already appeared for re-counselling. They have appeared for the counselling. And by virtue of WPS 1916, which was again confirmed by 168 of 17.
You see, have you read those judgments
Yes,
of Division Bench?
Yes, Your Worship.
What have you read about it? What is the
The
direction?
direction is that people who have already appeared for counselling, they cannot be given a
So
again a chance.
therefore, this case will be disposed of in terms of the Division Bench. You can't understand this.
Yes, Your Worship.
Then-
But then
Whatever order has been passed by the Division Bench, that has to be followed. A fresh counselling is to be done. If they are entitled by any means, by any chance, we do not know. If they are entitled, they will get it. If they are not entitled, they will not get it. Simple. लिखिए WPS number 900 of 2023. The Learned Counsel for the petitioners has submitted that the petitioners were para teachers and they had applied under para teacher category. She has also submitted that there has been repeated orders passed by this court and ultimately the petitioners were called for counseling but not selected. The learned counsel appearing on behalf of the respondents has submitted that no candidate having less marks than the petitioners have been selected. And as per the judgment passed by the Honorable Division Bench in LPA number 203 of 2022 and in LPA number 510 of 2023 and other analogous cases, fresh process has to be undertaken, and if the petitioners would be entitled in terms of such order, their case can be considered. Otherwise, and accordingly, this writ petition be disposed of in terms of the same judgment. Any objection to that? I have recorded your preliminary objections, right? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that arising out of the same recruitment process, two detailed orders have been passed by the division bench. One in LPA number 203 of 2022 and other in LPA number 510 of 2023. The operative portions of the judgment passed are quoted as under. This court is of the considered view that if the petitioners is found entitled in terms of the aforesaid judgments, then only their cases can be considered. This writ petition is accordingly disposed of.
Hospital case item 7, WPS 2030 of 2023.
Can we see the page number 53, 54 and 55 in my read petition? My lord, as I have shown from the matriculation marks, my lord, that I have obtained 408 marks, my lord, which is the second division. My lord, page 53, my form number is, my lord, 2151. My lord, this is the prayer number 2 of my read petition. In front of my form number 2151, that is my prayer number 2, my lord. The specific prayer, my lord, made by me.
No, what you just tell us,
My lord.
what is your marks given for matric?
Matric, my lord, they have given only 104.
Where is it mentioned?
Yes, that is page 54, my lord. पेज 54 का ऊपर वाला जो कॉलम है, ये हम दिखा रहे हैं ऑफिस ऑफ द डिस्ट्रिक्ट सुपरिटेंडेंट ऑफ एजुकेशन गिरिडीह, डाटाबेस ऑफ टीचर अपॉइंटमेंट 125 2015-16 का। इसमें लास्ट कॉलम में देखा जाएगा हुजूर, तो 104 नंबर एंट्री किया हुआ है। दिस इज द मार्क्स ऑफ मैट्रिकुलेशन दे हैव रॉन्गली एंटर्ड, माय लॉर्ड, वेयर एज माय लॉर्ड द
मैट्रिकुलेशन तो लिख ही नहीं रहा है इसमें। आप वो टॉप में देखिए क्या लिखा हुआ।
टॉप में OBT marks without text paper.
इसका क्या मतलब?
ये
This is not matriculation marks.
ये मैट्रिक का ही मार्क का है।
कैसे हम? मैट्रिक का कोई बात ही नहीं लिखा है।
हम बता रहे हैं इसको। इसका नेक्स्ट पेज में ये जो पूरा जो कैलकुलेशन, मतलब काइंडली फॉर क्लैरिफिकेशन, मतलब काइंडली सी माय रिप्रेजेंटेशन, मतलब पेज 57 इसमें हम मतलब दे हैव एक्सेप्टेड दिस फैक्ट, मैडम, कि ये रॉन्ग एंट्री किए थे। हम पेज 57 देखा जाएगा, जिसमें हम वो दिए थे कि डाटाबेस 2015-16 में अनारक्षित गैर पारा कोटि के क्रम संख्या 2151 में मैट्रिक अंक एवं प्रतिशत गलत दर्ज होने के संबंध में सविनय नम्र निवेदन है कि मैं अशोक कुमार महतो पिता सच्चन सच इतना में मेरा मेधांक अनारक्षित गैर पारा कोटि के क्रमांक संख्या 11-2151 में दर्ज है, जिसमें फॉर्म नंबर 2151 के क्रम संख्या 29-30 में मैट्रिक का प्राप्तांक एवं प्रतिशत दोनों गलत दर्ज है। मेरा मैट्रिक में प्राप्तांक 408 तथा प्रतिशत 45.33% है से द्वितीय श्रेणी से उत्तीर्ण हूँ, जिसकी छाया प्रति आवेदन के साथ संलग्न है, साथ ही
ये
डाटाबेस का
कहाँ
गलत दर्ज
लिखे
होने
हैं
की
कि 408 कहाँ होना चाहिए था, कौन से कॉलम में होना चाहिए था?
408 हम बता रहे हैं। अभी जो हम रूल 21 जो बताए, रूल 21 में जो क्लास 1 to 5 का जो मेरिट लिस्ट बनता है माय लॉर्ड, उसमें मैट्रिक, इंटर प्लस टीचर ट्रेनिंग तीनों का मार्क्स को एक साथ जोड़ करके 3 से डिवाइड कर
देखिए,
देगा।
इस तरह से लेक्चर नहीं सुन सकते हैं
And
आप।
that is
अपना
the rule, that
रिट
is the
पिटीशन में पैराग्राफ दिखाइए, हम उनका रिस्पांस देखेंगे।
हाँ।
बताइए
Yes.
कौन सा पैराग्राफ और उनका रिस्पांस देखेंगे।
Yes.
इस तरह से नहीं हो
yes,
सकता।
madam. Kindly see
बताइए।
the paragraph 6 में the in order to appreciate the fact involved in the
ये सीखेगा मैंडमस।
yes mandamus
आप एक ऑर्डर पास कर दीजिए, क्या बोलेंगे? हमको नहीं समझ में आ रहा है इनकी क्या।
केस बहुत क्लियर, एकदम स्पष्ट एंड स्पेसिफिक है। they have admitted in the counter affidavit।
उतना हमको समझ नहीं आ रहा।
नहीं समझ में आ जाएगा हुजूर, हम
नहीं,
समझाने के लिए है ना, एकदम स्पष्ट भाषा में बता देते
नहीं,
हैं
हम
हुजूर।
इतना देर से सुन रहे हैं, हम पूरा फाइल हम बहुत कोशिश की आपका केस समझने का, लेकिन हमको आप
एकदम प्लेन एंड सिंपल केस है, एकदम प्लेन एंड सिंपल के है। एक बार फिर से हम रूल 21 जो टीचर
नहीं, यहाँ पे नहीं ना डिसाइड होगा, उन्हीं को डिसाइड करना है। कौन डिसाइड करेंगे बताइए?
ये काउंटर में आए।
प्लीज होल्ड ऑन, आप एक सेकंड चुप रहिए प्लीज। आप मैंडमस मांग रहे हैं ना? हाँ, तो यहाँ से नहीं
मैंडमस में दे हैव कम विद द एफिडेविट कि इन्होंने डिसीजन ले लिया है।
नहीं,
बट वेयर इज दैट डिसीजन?
एक सेकंड प्लीज होल्ड ऑन। हाँ बताइए।
लॉर्डशिप, ये बीसी कैटेगरी में फाइल किए थे अपना आवेदन।
हाँ,
और
नहीं, खाली इतना बताएं कि 408 के जगह में 408 जोड़े थे कि 104 जोड़े थे। दैट इज द थिंग।
आप सवाल नहीं करिए उनसे प्लीज, आप बैठ जाइए।
दैट इज माय ग्रीवांस।
You are seeking a mandamus and I will not give a declaration from this court, right?
तो ये तो एकदम स्पष्ट है कि 408 के जगह में जो 104।
आप ये बताइए इनका ग्रीवेंस को कौन देखेगा? इनका हियरिंग करा के ऑर्डर कर दीजिए, बताइए। Who will take care of his grievance? DC?
इनका यस सर, डीसी के लिए
देखिए द लर्नर
इनका
काउंसिल,
मार्क्स ऐसे लास्ट सिलेक्टेड कैंडिडेट से कम आया है।
आपको जो करना है कर दीजिए। इनको
ठीक।
मैट्रिक में देखिए कि इनको ग्रीवेंस है कि इनका मैट्रिक का जो मार्क्स है वो ठीक से नहीं कैलकुलेट हुआ है। कैलकुलेशन तो यहाँ पे नहीं होगा, वो डीसी को ही करना है, तो उन्हीं से करवाइए।
ठीक।
The learned counsel for the parties are present. District petition has been filed for the following relief. The learned counsel for the petitioner submits that the grievance of the petitioner is that the petitioner had obtained 408 marks in matriculation, but while considering his allocation of marks on the basis of educational qualification, the marks has been wrongly taken as 104. And consequently,
of matriculation, 104 marks of matriculation marks. My grievance is only with regard to matriculation.
आप ऑर्डर नहीं लिखाने देंगे? नहीं,
नहीं लिखाई।
दिस
Order?
इज योर रिपीटेड थिंग। आप ही लिखाइए ऑर्डर।
नहीं, हम
6
सबमिशन
महीना बाद कर देते हैं, आराम से आते रहिए।
हम सबमिशन कर दिए।
और डिक्टेशन के बीच में क्या सबमिशन करना है?
ठीक है।
Marks has been taken as 104 instead of 408, and consequently the merit list point has gone down. The learned counsel has submitted that he has raised the grievance before the respondents, but as no order was passed, he has sought a mandamus from this court. He has also submitted that in the counter affidavit they have taken a stand that the petitioner has obtained less marks than the last selected candidate, but if the correct marks of matriculation is taken into consideration, he would come above such candidates, above the last selected candidates. Considering the nature of grievance raised by the petitioner and the relief as prayed for, this court is of the considered view that the grievance of the petitioner is required to be considered by the respondent number 3 at the first instance, as the manner in which the calculation with respect to educational qualification is concerned, the same has to be in terms of the advertisement and the applicable rules governing the petitioner. Accordingly, the petitioner may approach respondent number 3.
I have already approached the several representation, the repeated representation, the series of representation I have already made.
अच्छा, तो हम ऑर्डर नहीं करें कि आप जाएंगे वहाँ पर?
तो उसी को ये डिसाइड कर दें.
आपको हियरिंग नहीं चाहिए, फिर बोलिएगा हमको बिना सुने
हाँ,
ऑर्डर
तब ठीक.
पारा 17 ऑफ माय काउंटर रिव्यू टू पार्ट 2 उसमें मेरे सबमिशन में fifth last line.
I have written that his marks is less than the last
selected.
selected. Yes, I have written it. I have already dictated that. Accordingly, this writ petition is disposed of, enabling the petitioner to approach respondent number 3 by filing a representation, giving the details and a copy of the writ records within a period of 10 दिन में आप चले जाइए क्योंकि अभी रिक्रूटमेंट चालू है. Within a period of 10 days from today, upon filing of such representation, the respondent number 3 shall grant an opportunity of hearing to the petitioner and pass a reasoned order in connection with the aforesaid grievance of the petitioner relating to his consideration of matriculation marks. The reasoned order be passed within a period of 1 week from the date of representation and be communicated to the petitioner through speed post. ये पैरा टीचर ही है ना?
नॉन पैरा टीचर कैटेगरी.
नहीं, वही इतना रिक्रूटमेंट प्रोसेस है, सेम रिक्रूटमेंट.
हाँ, same recruitment.
The matter is required to be expeditiously decided by the respondent number 3, as the fresh counselling is likely to take place pursuant to the orders passed by the division bench in LPA number. वो जो 2 LPA number है ना, उसको लिख दीजिए.
This would communicate the order.
आप नहीं कुछ करेंगे?
हम कर देंगे, लेकिन ये कर.
LPA number 203 of
203 of 2020
22.
22 and analogous cases, and LPA number 510 of 22 and analogous cases. 23 है वो 510. चलिए.
Passport case from Regularization Item 9, WPS 6886 of 2023.
Whereas IA is being filed across the board, whereas we are seeking 3 weeks time to comply the earlier orders.
WPS number 6886 of 2023. IA number such and such has been filed seeking extension of time of 3 weeks to comply the order dated 28/2/2024. The learned counsel for the respondents has submitted that the counter affidavit, that should be sufficient. Let the counter affidavit be filed by 16th April. 3 हफ्ता से ज़्यादा हो गया और चाहिए टाइम. 23rd April. 23rd April 2024. IA number such and such is disposed of. Post on 30th April.
Pardon, seniority require clause 15(1) also. I think 15(2) also can be. 15(2) clause के सब 87 और 88 में वो जो क्लॉज 1 में है कि नहीं, और जो 94 में उसके लिए 15(2) है।
ऑर्डर में गलत हो गया कुछ?
कुछ करेक्शन टाइपिंग।
The learned counsel for the petitioner has submitted that the seniority list 15(1) लिखे हैं क्या?
यस यस
15(1) लिखे हैं ऑर्डर
जी।
में? The seniority list concerning the petitioner would be prepared in terms of clause 15 within bracket Roman 2 of the rules.
रूल्स।
Next call.
Item 10, WPS 6089 of 2023.
डेट में
डेट तो फिक्स कर दिया, आपको पता ही नहीं चला। बिना डेट के यहाँ कोई केस नहीं। दोनों केसेस है ना, दोनों केस में भी आई सेम है। ठीक है, सेम। कोई बात नहीं, एक में आइए फाइल के का।
Item 19, WPS 690 of 2023.
In this case, my lord,
WPS number 690 of 2023, counsel for the respondents is directed to seek instructions and file a counter affidavit in this case by 4th of April. Rejoinder by 16, post on 24th, under the heading for admission.
Item 20, WPS 1207 of 2023.
Same order.
Item 21, WPS 1244 of 2023.
may I please use? Thus, in this case, the petitioner.
Do you want to file any rejoinder to the counter affidavit? Do you want to file or you don't want to file?
Read back to
Not. Okay. Your name did not appear in Agarwal Commission report?
Yes, yes. That's why they are not considered. But if you also will see, the order by which my services has been regularized and absorbed, that has been done pursuant to an order passed by the Supreme Court of India. And
You were there in the.
yes, yes.
You were a party.
No, I was not a party.
Then
I was not a party before Honorable Supreme Court of India, but the judgment which has been passed by Honorable Supreme Court of India in the case of Mahasangh case Ulasi, that is 2005-9 SCC page 129, there was a direction given to the respondents to take decision. They have taken decision which is at Annexure 26 Ulasi, with respect to all such persons who are seeking absorption and who are not before the party. Page number 26.
Agarwal Commission was a part of that particular order only.
Yes.
That particular proceeding only.
Yes, yes.
Your name did not appear in Agarwal
Yes, that
Commission.
was not there.
Then,
But even then you will see.
even irrespective of Agarwal Commission
Yeah.
report, you are entitled.
Yes, that's my submission, and in fact they have considered and they have given to many others. For that, I would like to invite
To
Ulasi's attention.
which person who have given whose name was not there in Agarwal Commission?
Ulasi, directly I will bringing Ulasi's attention to page number 26. Where
You get the judgment tomorrow, we'll see. कल लेके आइए जजमेंट। कौन सा जजमेंट है? साइटेशन बताइए।
वो किसका दिए हैं उसका साइटेशन नहीं, जिसका हुआ है उसके लेके लेके आए।
किस ऑर्डर के तहत आपका ऑर्डर हुआ है उसका साइटेशन। You said no, the Mahasangh case.
Yes, Ulasi.
What is the citation?
2005-9 SCC page 129 Ulasi.
2005-9 SCC
Page 129 Ulasi.
129.
Ulasi, for a
कल
moment.
सुनेंगे। बिना जजमेंट के कैसे? आप तो नहीं लेके आए हैं।
हम लाए हैं जो कवर्ड है, जो अभी कोऑर्डिनेट बेंच का ऑर्डर हुआ है वो लाए हैं।
सुप्रीम कोर्ट के ऑर्डर देखेंगे ना, और कोऑर्डिनेट बेंच का जजमेंट भी देखेंगे। लाइए, कौन सा जजमेंट है?
Recently, serial number 5 का जो हुआ है वो नेक्स्ट 4 पेज 26 में
उनका भी अग्रवाल कमीशन में नाम नहीं था।
वो एसबी से
कहाँ से पता चलेगा? इस ऑर्डर में कहाँ से पता चलेगा?
Your Lordship, may kindly see page 3, Your Lordship, of that order. Mr. Indranil Wadri, Learned Counsel, appearing for the respondent state submit that the main ground for refusal for grant of approval of revised pay scale is that the report of Honorable Agarwal Commission as well as in the report of Justice S.B. Sinha Commission, the name of the petitioner does not find place. Only difference is that this petitioner has even approached Justice S.B. Sinha Commission, that Mr. Upendra Prasad, but I have not approached you, even Justice S.B. Sinha. Mainly for the reason, Your Lordship, that Justice S.B. Sinha Commission was meant for only such persons whose absorption was in dispute. My absorption was not in dispute because it has been done pursuant to the order passed by the Supreme Court in Civil Appeal number 6098 of 1997. That is evident from Annexure 4, page 26.
I'll hear you tomorrow.
As Your Lordship.
Counsel for the petitioner is present. He submits that the petitioner would be entitled for the relief as prayed for in this writ petition, irrespective of the fact that the petitioner did not approach, and the name of the petitioner does not find place in Agarwal SC Honorable Justice SC Agarwal Commission report. The Learned Counsel has relied upon judgment passed by this court in WPS number 5151 of 2016 dated 18/9/2023 and has submitted that he shall place reliance on the judgment passed by the Honorable Supreme Court reported in bracket 2005 bracket close 9 SSC 129. Post this case tomorrow. एक और जजमेंट हम लोग इस पे किए हैं, उनको बोलिएगा खोलने के लिए। आप ही का केस में किया?
हाँ।
कहाँ है वो?
है मेरे पास।
हाँ तो लेके आइए।
और Your Lordship,
ये है ना?
है।
हमको याद है, हमको याद पड़ा
और
ना।
in fact,
क्या किया हम उसमें?
Your Lordship has remanded by the matter and they have considered and given benefit.
तो वो ऑर्डर भी लेते आइएगा फिर।
उसमें केवल ये एसपी सिन्हा एससी अग्रवाल कमीशन में उनका नाम था, तब पर भी नहीं कर रहे थे, लेकिन हुजूर के ऑर्डर रद्द कर दिया।
नहीं नहीं, एक ऑर्डर हम किए हैं जिसमें एससी अग्रवाल में नाम नहीं था।
नहीं था, नहीं वाला भी और जजमेंट से कुछ लेके देंगे।
Please, Your Lordship, permission. The serial number 20, Lordship. I am for the petitioner.
कॉल आउट हो गया क्या?
Yes. Yes, I got the counter affidavit, the copy of the counter affidavit. हो सकता है फाइल नहीं कर पाए, कल ही दिया है। तो फर्स्ट वीक ओपनिंग वीक में रख दिया। हम उनको
हमको नहीं पता है अभी। अब ऑर्डर कर दिए, क्या होगा? बोल दीजिएगा काउंटर फाइल।
10 के अंदर कोई भी डेट देते हैं, हम जहाँ से बाहर के।
10 तारीख का तो डेट दिए काउंटर फाइल करने के लिए, आप तो बोलते हैं
काउंटर है जैसे आई गॉट योर
जब केस कॉल आउट होता है तब आप लोग रहते नहीं है। आई कांट चेंज द ऑर्डर्स लाइक दिस।
तो उसमें हम ठीक है काउंटर हो सकता है काउंटर पे एक्सेप्ट नहीं हुआ होगा, 48 आवर वाला तो उसको
घर में फाइल देखे थे उस समय काउंटर नहीं था।
सर
प्लीज डोंट डिस्टर्ब अस। हम डेट नहीं चेंज
24
करेंगे।
अप्रैल को रखा है, हम उनको सूचना दे देंगे।
आपका कोई भी रहेगा हम एडजर्न कर देंगे। कॉल करिए। हु इज देयर? पिटिशनर।
Item 22.
यस पिटिशनर।
Petitioner was appointed as an assistant in Ghatsila College, Ghatsila, on 1/7/1978, and against the sanction post, my lord. And thereafter he has also got the 4th pay revision, my lord. But my lord, in the year on 21/1/1995, one letter has been issued by the university, my lord, in which, my lord, he has been regularized from effect from the 20/8/93 में।
आप तो खाली मैंडेमस मांग रहे हैं। दैट ऑर्डर इज नॉट अंडर चैलेंज। यू आर जस्ट सीकिंग अ मैंडेमस।
My lord, Annexure 4 I have been challenged.
नो, देयर इज नो चैलेंज टू एनी। बताइए कहाँ है? कौन सी चीज का क्वेश्चन मांग रहे हैं आप?
My lord, I have stated for issuance of the inappropriate date, my lord.
Unless you challenge that particular date of that document, how do we just give a mandamus like this?
My lord, I read it, my lord, in prayer, my lord. For issuance of an appropriate date, nature, mandamus, any other appropriate date, which respondent concerned for confirmation of the service of the petitioner from the date of the appointment.
And a different date has been given in your confirmation. No, so that has to be challenged to that extent. It can't be like this.
I
My
want
lord,
to
please come to page 26. Annexer
26.
4. My lord, this is an order of 1995. 28 years have passed. Is this risk maintainable after 30 years? My lord, please come to page 26 and come to page 27 and see the date. 20th January 1995. My lord, please come to page 27 where the date of signature has been given. A.K. Srivastava, Registrar, Ranchi University. The order under challenge is 20th January 1995.
He has not challenged it also.
No, my lord, and please come to page 26, sixth entry from the top. A.K. Singh, S.K. Sinha, J.M. Giri, R.P. Singh, M.P. Singh, B.N. Singh, S.R. Giri. The date of regularization is 1st of August 1993. 1st of August, my lord. Just 2 minutes, my lord. 1st of August 1993. And now, my lord, please go to the office order. What does it read? That's very important. The following is the list of employees regularized against this post-sanctioned. Mark these words, my lord. Post-sanctioned under a staffing pattern. There was earlier an order of the Patna High Court that certain posts existing prior to August 1976, 50th August 1976 will be deemed to have been.
एक second. WPS number 21285 of 2023. The Learned Counsel. ये नहीं चलेगा. 95 का order.
Judgment has already been. I have annexed to my lord.
In your case.
No.
No, another similar case, my lord.
That's not
Similar
applicable.
case
I will
by
distinguish that. It's not applicable. I will
Which
distinguish.
judge?
Ratni will now
Annexure
is
5 and my lord one page 32, my lord, the Vijay Kumar Das, same and similar nature, my lord.
His name is also there in the list.
No, my name is not there.
No,
here.
his name is Vijay Kumar Das. His name is there in the list.
He has also been regularized from the 1/8/1993, my lord. By the said letter, my lord.
Which letter? Show me that his name is also appearing in this list.
As per annexure 4, my lord, Vijay Kumar Das.
Show the name of Vijay Kumar Das
My lord.
in this list.
My lord.
Where is the
this
name
list, my lord? This is a list of only my college, my lord. But Vijay Kumar Das is also working in another college, my lord. Who was also regularized from 1/8/1993, my lord. And my lord, the one judgment has also been passed by the Honorable High Court, my lord. Kindly see page 32, my lord. Permitted to read it, my lord. Same and similar nature. I read it, my lord.
Page number?
Page 32, my lord.
Yes.
I read it, my lord.
This is on the issue of payment of post-retirement benefits to a person having not been appointed
No,
in a
that's-
sanctioned post and retired.
And
There is nothing.
Nothing.
No, there is nothing. You just tell us.
I read it, my lord. Same and similar nature.
No such prayer is there with regard to changing the date of regularization.
हम इसको पढ़ते हैं एक बार.
नहीं, आप हमको बताइए ना, डेट ऑफ रेगुलराइजेशन का रिलीफ है क्या इसमें?
ये इनका भी सेम वही है.
क्या वही?
देखिए ना यहाँ पे.
इसमें डेट ऑफ रेगुलराइजेशन का रिलीफ है क्या इसमें?
हाँ.
हाँ बताइए कहाँ पर है, कौन सा रिलीफ है? प्रेयर 1 में तो नहीं है।
वन में नहीं है.
हाँ।
रत्नी और राम ने दिखा दिया।
नहीं, इसी में है तो विजय कुमार दास में भी है.
पहले एक जजमेंट में आइए।
रत्नी और राव पर इलाज कर रहे हैं।
पेज 35 का एनेक्स पैरा सेकंड में हम पढ़ते हैं.
रत्नी और राव traveled up to Supreme Court. इसमें
Page
दिखाई
35 का in the aforesaid fact and circumstance therefore appears that the respondent state on the one hand has failed to take the conscious decision in matter of the recognition of the petitioner service. All along, though it has released the benefit of the pay revision to him prior fifth pay revision, and now after his retirement, a question is being raised in relation to the regularization of his service, which is contrary to a stand taken by the university on the strength of their letter dated 21/1/1995, my lord. This letter, wherein the petitioner was regularized with effect from 20/11/79, my lord. This is the appointment letter of the Vijay Kumar Das.
So he was regularized with effect from 2011-1979.
Vijay Kumar Das has regularized 2011-1979. Now I have regularized
You are in a different institution altogether, isn't it?
1/8/1993, my lord. And prior to this date, my lord, I have already been regularized by the university, and fourth pay revision has also been got.
You were regularized against this Vijay Kumar Das was regularized against a sanctioned post of LDC with effect from 2011-1979.
My
Where is your order of regularization with effect from 2011-1979?
lord. I my lord, kindly see page annexure 2, page 20, my lord. शिक्षकेतर कर्मचारियों की स्वीकृत पदों और नियुक्त कर्मचारियों का विवरण एनेक्चर 2 में। तो इसमें आई एम एट सीरियल नंबर 11 में।
These are the details from which you are working.
My lord.
You can be regularized only
It
when
has been issued by the
a post is sanctioned.
Next, my lord, annexure 3, kindly see page 22. My lord, the claim of area from 1481 to
These are all claims.
fourth pay revision. My lord, after confirmation of this post, my lord, the fourth pay revision has also been paid to this petitioner, my lord.
With
My lord,
effect
I
from
read
which
it.
date?
Huh?
With effect from which date?
My lord, I read it, my lord, continuation on this office.
If everything has been paid to you, is there any order of recovery from you? No.
No,
Then-
not recover. But
Then-
my lord, the one common letter has been issued by the university. And that, as per that letter, my lord, we have been regularized
Just
after 1/8/1993, and so many persons have
Please
been
hold on.
considered.
Heard the learned counsel for the parties, district petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner is seeking a direction upon the respondents for confirmation of his service with effect from his initial date of appointment, that is 1/7/1978.
My lord.
The learned counsel appearing on behalf of the respondents has submitted that the prayer sought for by the petitioner is contrary to the document as contained at Annexure 4, wherein a specific office order has been issued way back as on 21/1995, clearly mentioning that the petitioner S.R. Giri, library assistant, grade 3, though joined on 1/7/1978, but his date of regularization is 1/8/1993 in terms of government letter number 28/1993. The learned counsel submits that the order as contained in Annexure 4 is not under challenge, nor the government letter dated 28/1993 is under challenge, and therefore no mandamus.
The letter number is 1154.
Letter number 1154 dated
Lordship.
28/1993 is under
Lordship.
challenge. He submits that in such circumstances, no mandamus be issued
My lord.
in terms of the prayer as made by the writ petitioner.
My lord, one liberty.
After hearing the learned counsel for the parties and considering the nature of relief as prayed for by the petitioner, this court finds that on the face of Annexure 4, no mandamus as prayed for by the petitioner can be issued. Accordingly, this writ petition is dismissed.
My lord, in similar nature, my lord, the two case order.
कुछ नहीं हो सकता, mandamus आप prayer ही बनाने नहीं आता आपको तो हम क्या कर सकते हैं?
हुजूर, एक बार हमको चांस दे जाए, आइए, I want to file the IAS.
Same. प्रेयर बनाने नहीं आता, इतना देर से बोल रहे हैं, बात ही नहीं समझ में।
Item 23, WPS 1293 of 2023.
In this case,
इसमें क्या है?
my lord, in this case, my lord, the petitioner was appointed as an assistant librarian, my lord, 12/1/1980, and my lord, the college has also recommended for making the 4th, 5th and 6th pay revision, my lord, but my lord, the university has rejected the claim of this petitioner.
Where is the order of rejection? And is it under challenge? Yes. Annexure 6. Annexure 6, page number. You have filed your counter?
6. No.
You filed your counter?
Yes.
Learned counsel for the parties are present. Counsel for the respondents are directed to seek instruction and file a counter affidavit in this case by 24th of April, rejoinder by 3rd of May, post on 8th of May, under the heading for admission. Next. वो एक जजमेंट 15 मिनट लगेगा एक जजमेंट हमको डिक्टेशन देना है उसके बाद कुछ टाइम मिलेगा तो वी विल टेक अप द मैटर
कॉपी लेना स्टेट से बहुत मुश्किल हो जाता है तो इतना कॉपी मिलता है
क्या चीज़ का
पिटिशनर को कोई भी कॉपी स्टेट से लेना बहुत मुश्किल हो जाता है फाइल करने के लिए
आप लोग प्रेयर ही नहीं बनाने जानते तो
वो क्या कहेगा ऑर्डर तो आता नहीं है होता
Case item 98, WPS 5876 of 2023.
WPS number 5876 of 2023. Heard the learned counsel for the parties. This petition has been filed for the following relief. एक और ऐसा अलग से होगा है ना नहीं ठीक The foundational facts of the case are that the petitioner was appointed as assistant engineer on the recommendation of BPSC by letter dated 26/1987 in the Water Resources Department, Government of Bihar, and he joined on 22/6/1987. The petitioner is governed by the provisions of Bihar Engineering Service Rules 1939. वो लिखने का जरूरत नहीं. The promotional avenues of the petitioner is from assistant engineer to executive engineer to superintending engineer, then to chief engineer and to engineering chief. After bifurcation of the state, the petitioner was allocated Jharkhand cadre in the year 2004 and was promoted as executive engineer on 9/6/2014, and thereafter, upon expiry of 1.5 years, he was notified as a regular executive engineer by letter dated 30/11/2015, and his pay scale was also mentioned therein. It is the case of the petitioner that there were altogether 42 posts vacant, 42 posts in the rank of superintending engineer SLK. There were altogether 52 posts of superintending engineer, 12 for chief engineer and 2 for engineering chief in water resources department. And out of total of 66 posts, 33 posts were in the rank of superintending engineer, 8 posts in the rank of chief engineer, and 1 in the rank of engineering chief for the unreserved category. The final gradation list was published on 2/4/2013, which was followed by notification dated 30/11/2015, and ultimately the provisional gradation list of regular executive engineer was notified by notification dated 9/1/2017 as on 1/6/2016, and the seniority position of the petitioner was at 42. The petitioner was entitled for promotion to the next higher post in terms of letter dated 24/10/2014. But was granted promotion by notification number 3093 dated 25/9/2018, though he was entitled with effect from 30/11/2016. The grievance of the petitioner is that the petitioner, being eligible for promotion as on 30/11/2016, the petitioner is entitled for notional promotion with effect from the same date, and the notification dated 29/2018 is required to be modified, giving the petitioner retrospective promotion, including all consequential benefits, the counsel for the petitioner has relied upon the judgment passed by the Honorable Supreme Court in the case of Ajay Kumar Shukla and others, 2021 SCC Online SC 1195, to submit that the petitioner had a right to be considered for promotion at the appropriate time. He has also relied upon the judgment passed by Honorable Supreme Court in the case of Ajit Singh versus State of Punjab, reported in bracket 1999 bracket close 7 SCC 209, to submit that it has been held that if a person is eligible for promotion but still has not been considered, that amounts to violation of fundamental rights. The Learned Counsel has submitted that as per the notification dated 24/10/2014, issued by the Personal and Rajbhasha Department of the respondents, they are under an obligation to conduct. नहीं, ये notification का date ही नहीं है. Notification dated 4/4/2014. The issued by the Department of Personal and Rajbhasha Department, the respondents are under a legal obligation to conduct minimum 2 departmental promotion committee meeting every year, and the policy decision of the state has been violated by the state themselves, and therefore the petitioner, having attained the age of attained the requisite for consideration of promotion on 30/11/2016, the petitioner is entitled for retrospective promotion with all consequential reliefs. The Learned Counsel has also submitted that the respondents have taken a stand in the counter affidavit that there was an interim order of stay passed in WPS number 3792 of 2016 within bracket Amrendra Kumar Singh versus State by order dated 27/2/2017, and the order was vacated on 27/6/2018. The said stand is misconceived in as much as the petitioner had become entitled for promotion with effect from 30/11/2016 prior to the stay order passed by this court. The Learned Counsel has also submitted that the in the judgment passed that wide notification number 6752 dated 24/12/2020, the Personal Department of the state had passed a blanket order to stay all the promotions which were subject matter of challenge in WPS number 1390 of 2021 and WPS and other analogous cases, and ultimately the same was quashed and set aside with directions contained therein, and the respondents have taken a conscious decision to relax the provisions of Rule 58 and Rule 58 of the Jharkhand Service Code and Rule 74 of the financial rules in order to give retrospective promotion. The Learned Counsel submits that the respondents, having not conducted the departmental promotion committee meeting at the relevant point of time, the provisions of Rule 58 of Jharkhand Service Code and Rule 74 of the financial rules will not come in the way of the petitioner to claim promotion with retrospective date. That's all. That's all. I can't hear you. I can't hear you. Yes, down here. I've recorded all your submissions?
Yes, madam.
Yes. That's all. Please mute yourself. The learned counsel appearing on behalf of the respondents while opposing the prayer has submitted that the petitioner has a right of consideration of promotion and there is no right to seek promotion. The learned counsel has further submitted that the circumstances in which the departmental promotion committee was held later on has been duly explained in the counter affidavit, and the petitioner having not joined the promotional post on 31 with effect from 30/11/2016, there is no question of grant of any retrospective promotion to the petitioner. He has relied upon the provisions of Rule 58 of Jharkhand Service Code and 74 of the financial rules. The learned counsel has submitted that so far as the order passed in the case of the learned counsel has submitted that the petitioner has attained the age of superannuation on
31st of October 2019.
31st of October 2019, and after his superannuation, the petitioner is claiming the benefit. And in view of the stand taken in the counter affidavit, the petitioner is not entitled for retrospective promotion. He has also submitted that the petitioner has already availed all the financial upgradation which the petitioner was entitled on account of, in lieu of promotion, right? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the petitioner was initially appointed as Assistant Engineer in Water Resources Department on 22/6/1987 and was given regular promotion to the post of Executive Engineer by notification dated 30/11/2015. The first ACP was granted to the petitioner with effect from 9/8/1999 and white notification dated 4/3/2005 in the pay scale of rupees 10,000-325-15200. Upon completion of 20 years, the petitioner was also granted MSCP by notification dated 6/11/2013 with effect from 1/9 in the pay scale of 15,600 to 39,100 with grade pay of 7600 with effect from 1/9/2008. And upon completion of 30 years of service, the petitioner was granted third MSCP by upon completion of 30 years of service by notification dated 7/6/2018 with effect from 22/6/2017. The petitioner became eligible for grant of promotion with effect from a grant of promotion as on 30/11/2016, nay, this court further finds that as per the claim of the petitioner, he became entitled for promotion to the post of superintending engineer with effect from 30/11/2016, and the departmental and in the meantime there was an order passed by this court in or there were, in the meantime there was an immediately after the petitioner immediately thereafter an order dated 27/2/2017 was passed by this court in WPS number 3792 of 2016, wherein an order of stay was granted in connection with promotion, which stood vacated on 27/6/2018 by the order of this court, and the said case remained pending. इसका disposal date बताइए तो, WPS number 3792 of 2016. And thereafter the meeting of the Departmental Promotion Committee was held on 30/8/2018, and recommendation was made, and the petitioner along with other persons were granted regular promotion.
6 March 2012.
And the petitioner along with other persons were granted promotion by notification dated 25/9/2018. The writ petition being WPS number 3792 of 2016 has been disposed of by this court ultimately on 6th of March 2024. However, the final order of the said judgment has not been placed on record. आ गया क्या? This court finds that it is not the case of the petitioner that any person junior to the petitioner has been promoted and the petitioner has been left out. There is no doubt that the petitioner has a right to be considered for promotion, but has no right for promotion as such. This court finds that non-convening of Departmental Promotion Committee meeting during the period from 30/11/2016 till what was the date? Till 30/8/2018 has been well explained by the respondents in the counter affidavit. This court also finds that the merely because the petitioner was eligible for consideration of promotion, that by itself does not crystallize any right upon the petitioner to claim promotion from the date the petitioner had become eligible. As per the circular of 2014, Departmental Promotion Committee meeting is required to be held twice a year, and immediately after the petitioner claims to have become entitled on 30/11/2016, interim order was passed by the High Court. In the month of February, डेट बताइए, was passed by the High Court. This court is also of the view that merely because the respondents are under an obligation to convene departmental promotion committee meeting twice a year, that by itself and non-convening of any such meeting by itself does not entitle the petitioner to claim promotion from the date he becomes eligible for promotion. There is no such provision has been brought to the notice of this court by the counsel for the petitioner. Rather, as per the provisions of Jharkhand Service Code, Rule 58 as well as Rule 74 of the Jharkhand Financial Rules, the person is entitled for the benefit under the promotion only when the incumbent joins the promotional post. It is not the case of the petitioner that the petitioner was made to work on the promotional post without giving him any promotion. So far as the order passed in the case of so far as the blanket order passed by order of stay with regard to promotion by memo number 6752 dated 24/12/2020 is concerned, the same was passed much after the petitioner had attained the age of superannuation. Further, this court, while quashing such blanket order of stay on promotion, had passed certain directions, and the respondents in terms of such direction have acted and have relaxed certain conditions which are prescribed under Rule 58 of the Jharkhand Service Code and Rule 74 of the Financial Rules. Therefore, this court is of the view that petitioner cannot have any advantage of the order passed by this court in WPS number 1390 of 2021 and the policy decision of the state government as a follow-up of such decision. This court is of the view that on the face of Rule 58 of the Jharkhand Service Code and the financial rules, the petitioner cannot claim any retrospective promotion and financial and consequential benefit arising therefrom. In view of the aforesaid findings, this court finds no merits in this writ petition, which is accordingly dismissed. It will have certain corrections. The judgments which they have cited, I will quote the relevant paragraphs of that judgment. You give me quotation of Rule 74 of the Financial Rules. I was not able to find it out. कितना केस बचा है फ्रेश फाइलिंग? कल का कितना फ्रेश फाइलिंग? आज का सारा फ्रेश फाइलिंग कल रहेगा रिमेनिंग।
एडमिशन में एक में 84 था, उसमें 6 महीना पहले काउंटर के लिए हुआ था, आज तक काउंटर नहीं फाइल किया है, डिस्मिसल मैटर सीरियल 84 है। प्लीज दिस शुड फाइल काउंटर।
कौन है काउंटर फाइल करने वाले? स्टेट है, सीसीएल है कौन?
स्टेट
हु इज फॉर द स्टेट इन सीरियल नंबर
84।
84? सीरियल 84 में आप बता देंगे मैडम, रिकॉर्ड कर दें अपीयरेंस काउंसिल का सीरियल नंबर 84। In spite of order passed by this court, no counter affidavit has been filed. Let the counter affidavit be filed by 10th April.
सीरियल 27 जो कल मैडम
एक सेकंड रुकिए,
सॉरी
by 10th April, post on 15th, ठीक है? उस समय रिजॉइंडर की जरूरत होगी तो रिजॉइंडर कर देंगे।
सीरियल 27 में कल भी एक वैसे मैटर था विदाउट सबमिटिंग एनी रिप्रेजेंटेशन आई अप्रोच दिसंबर।
सेम ऑर्डर
एग्जैक्टली वही रिलीव भी है, वही सब कुछ है, लेकिन
कौन सा केस का नंबर बताइए?
सीरियल जो हो चुका है सब
हाँ, नहीं 27, उस केस का नंबर भी बताइए और 27
1378 of 2023
1378 ऑफ 2023।
और उसमें जो डिस्पोजल हुआ वो रॉन्गली लिस्टेड है आज भी। वो
अच्छा।
तो डिस्पोजल हो गया, लेकिन नोट आया है कि रॉन्गली लिस्टेड।
अच्छा।
यस्टरडे इट वाज
हाँ
डिस्पोज्ड।
बताइए।
3575/23
3575 by
23 विजय कुमार पासवान।
2023।
एग्जैक्टली
order.
सेम है, एग्जैक्ट लाइन बाय लाइन वही, सिर्फ पीरियड अलग।
सुनिए एक सेकंड, समझ लीजिए। आज एक केस लिस्ट में है 1378 ऑफ 23, ठीक है? इसमें आज की डेट का डिस्पोजल करना है। ये 3575 ऑफ 23 ये कल लिस्टेड था, आज भी लिस्टेड है, रॉन्गली लिस्टेड है। कल इसमें जो ऑर्डर
आजकल
हुआ है
इसमें 53
सिमिलर ऑर्डर इसमें करना है।
सीरियल 53 में आज लिस्टेड
आज वो wrongly हो गया है।
रॉन्गली है, लिखा हुआ
ठीक।
नोट।
ठीक, आप समझ गए ना? तो वो एक ये वाला 1378 सेम ऑर्डर
सीरियल 27
आप है
फॉर द स्टेट।
सेम है, सेम कहानी।
हाँ।
He has not,
53.
you see, yesterday we had taken up a similar matter where he had not represented and he was seeking a mandamus. So I say
Permission
that
has
no
been granted.
mandamus can be issued, but he can pursue his remedy ऐसा
granted
कुछ।
to file a
हाँ,
representation।
उतना ही भर है, ठीक है? काउंटर इसमें आया है क्या?
नहीं,
नहीं, उसमें भी नहीं आया।
काउंटर नहीं है।